And I was sitting there wondering, there's a man called Anthony Ochiengor, aka Ochibaba. I was wondering whom he would ask what Istilahi means, because I suspected that Ochibaba would find solace in asking Maura Wakavata, who may also say, I don't know. Then I regard myself as a fair speaker of Kiswahili, because as an 844 graduate, Kiswahili is a compulsory language in our school, so I didn't escape it with good grades. But for the first time, I learned the distinction between mlalamishi and mlalamikaji. And I wondered how much more I don't know. So, Dr. Masi Mwara Deche, next time you see in Mombasa avoiding Kiswahili, no, it's out of fear of just how much more don't I know. This conference is useful for me again because I have discovered the place of trauma in life. There is a man called Evan Sogada who has used the word makofi ya Nyayo so many times that I think he's yet to recover from the Nyayo trauma. I hope those of you who pray can pray that that Evan Sogada eventually recovers from the trauma of the Nyayo era. My brief remarks this morning are under the theme, our role as Kenyan advocates in recentering the rule of law for sustainable development in a fast-changing world. I begin by reflecting on this conference itself, and I observe that there are many times in life when we look back and we can't do anything else than just admire those who came before us. A good example is that actually somebody sat down and conceptualized the idea of an annual conference for lawyers. I speak on good authority that none of the people sitting in this room can speak with the finality of what is the number of conferences in the nature of the annual conference for the LSK have been held this far. If I tasked people here to tell me which number is this conference, none of the people sitting in this room may authoritatively answer that question. And I begin by this example because at the end of this conversation, I'm going to challenge us to invest a little more in our legal history and the history of outstanding legal personalities in this country. My research on this subject made me to talk to a number of people, among them Mr. Kitheka, who has always guided me on this conference, Mr. Ongicho, a man whom I have significant respect for. If I get time today, I'll say what that respect is founded on, who informed me that the first LSK annual conference was held in 1988 at a venue that no one remembers. I don't know what quality of conference it was or what backlash it attracted from members because the annual conference was discontinued after the first conference. We had to have another conference 80 years later in 1996 at Utalii Hotel in Nairobi. Subsequently, there was a conference in 1997 at Safari Park Hotel in Nairobi and 1998 at the White Sands Hotel in Mombasa. I'm informed the attendance at the 1998 conference at White Sands in Mombasa was between 15 and 18 participants, members of the Law Society of Kenya. Thereafter, we had subsequent conferences for each succeeding year until 18 years ago, when this conference moved to the Elisha Lodge, where we are at the moment. And I'm told for the past 18 years, we've been holding this conference at the Elisha Lodge, except once, when we moved at the Pride Inn with adverse consequences. Adverse because the Elisha Lodge is located near a road with fast-moving traffic. And people who come from Manyata, to put them near a road with fast-moving traffic is to endanger the lives of lawyers. We must therefore look back with a measure of appreciation, one, to those who came up with this idea, and two, to those who work tirelessly behind the scenes to make this idea even possible. I mean, when you sit in this room and see all these screens working here, all those cameras working there, and people moderating this event seamlessly, there are certainly physical and intellectual efforts behind the scenes that are making this possible. Let me not mention, number one, the food that we find readily available at comfortable serving point and the alcohol that you have been promised this evening. Allow me to then delve into the more substantive parts of my conversation with you by making some remarks that I consider unequivocal just as I consider them to be true. The first unequivocal remark that I make is that every generation in human society has an obligation to define its generational challenge and to fashion a solution to that challenge. I consider the greatest challenge of our present generation to be how to secure a just state by just means. Secondly, I make another unequivocal statement, I also regard it as true, that the Constitution of Kenya 2010 is a law that aims at creating a just state by just means. Why do I say that? Our Constitution of Kenya is a collection of many values, many obligations, many institutions, many rights, all of them clothed together. I want to persuade you that the most enduring value in the Constitution of Kenya 2010 is the value called social justice. Our teacher yesterday, who has been my teacher for many years, Feroz Norovji, taught me that if you look at the Constitution of Kenya 2010, you will discern multiple aspirations for social justice. A good example is the preamble, which sets out the aspiration of all Kenyans for a government based on essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. You'll find social justice in Article 10 of that Constitution, Article 19 of that Constitution, to mention but a few. The third unequivocal remark that I make, again derived from the writings and the teachings of Feroz Norovji, Senior Counsel, is that the Constitution of Kenya 2010 places the task of securing a just state by just means in the legal profession in this country. I guess it is against that background that Feroz Norovji taught us yesterday that we are actually a constitutional organ or a constitutional institution, whichever you find more fanciful in reference to yourself as a person. Fourth, and I believe this will be self-evident and easy to sell among all the men and women in this room, is that the Law Society of Kenya exists for the sole purpose of pursuing noble objectives. Key among these noble objectives are, number one, to maintain and improve the standards of conduct and learning of the legal profession in Kenya, to facilitate the acquisition of legal knowledge by members of the legal profession and others, to assist the government and the courts in all matters affecting legislation and the administration and practice of the law in Kenya, to represent, protect, and assist members of the legal profession in Kenya in respect of the conditions of practice or otherwise, to protect and assist the public in Kenya in all matters touching, ancillary, or incidental to the law, to do all such other things as are incidental or conducive to the attainment of all those objectives I have mentioned above. Now, for those who are more keen among us know that these are not products of my ingenuity. These are products of Section 4 of the Law Society of Kenya Act. The fifth unequivocal remark that I make is that these objectives directly or indirectly call on the Law Society of Kenya and therefore the members of the Law Society of Kenya to pursue the ideals of excellence in learning and practice, in the rule of law, social justice, the common good, and the rule of law. It is the late Sir George Rukwaro, one of the pioneer deans of the School of Law at the University of Nairobi, who taught us in his writings, I never met him in person, who taught us in writings that an ignorant mind is necessarily an underdeveloped mind, and that such a mind will not know its rights, let alone knowing when they are violated. To tell an underdeveloped mind to protest a violation is to expect too much from it because it can't detect the violation in the first place. So excellence is a conditio sine qua non for us to be able to make a significant contribution in the pursuit of the ideals of a just state by just means. Sixth, and finally, I make another unequivocal statement that the realization of these objectives and the fulfillment of the obligation to secure a just state by just means, which is placed upon the legal profession in Kenya, is not going to be an easy task. It is not going to be a walk in the park. It's going to require strategic thought, preparation, planning, and what I call long-term, solid determination. It requires a spirit of excellence in all the manifestations of that spirit. I have chosen a deliberate topic for this presentation, being our role as Kenyan advocates in recentering the rule of law for sustainable development in a fast-changing world, deriving from the theme of this conference. But at the heart of that presentation, there is a supposition that the rule of law either has been or appears to have been dislocated from the center. There's an assumption that the lawyers perceive or understand that dislocation, or better still, they actually know where the center is supposed to be. That's the only way we can recenter the rule of law back to where it is supposed to be. To attempt this task, I propose that we reflect on the following questions together as we further this conversation. The concept of the rule of law evolves as we continue to hold institutions accountable. The question is this: does the Law Society of Kenya, as an institution to which we are members, have the requisite tools and objective criteria on which we can assess the performance trends of those we are seeking to hold accountable, so that we can give them a score sheet that tells them how they are doing, whether they are improving, whether they are average, whether they are below average, whether they are surpassing our expectations on the rule of law index. Number two, I pose as a challenge to us: have we sufficiently introspected on our future as a profession and the future of enduring principles such as the rule of law in the face of the fast-changing world, key among them emerging technologies such as artificial intelligence? The chief guest says that if you speak without mentioning AI today, you look like you are foolish. So I would want to look like many things, but not like I'm foolish. So I have exhausted my reference to artificial intelligence, and I trust as you go away, you say I didn't look that foolish because I used that word. The third question that I pose is, what is our role as advocates in recentering the rule of law to meet the needs of concepts such as sustainable development in a fast-changing world? And finally, in light of all these other questions I've posed above, what is our key drive as members of the legal profession in Kenya? Is it excellence or bare survival in difficult economic times? I'd not want to bore you with the theoretical foundations of concepts such as the rule of law. Safe to point out that from the earliest of times, when people like Albert von Dicey reflected on this concept as an academic concept, to the time when jurists have reflected on these concepts, and I remember the International Commission of Jurists coming up with definitional ingredients of the rule of law in a declaration in New Delhi in India many years ago, the concept has continuously been refined. Today, there are institutions across the world that are evolving an objective criteria, some indicators on which to assess societies in terms of the rule of law performance. Key among this is the World Justice Project Rule of Law Index. I observe that if you look at the indicators by the World Justice Project, they include constraints on government power. You reflect on a society and you ask, to what extent are there both textual and practical constraints on government power in that society? Absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil justice, and criminal justice. So you can assess how we are performing as a country along each of these indicators to see where we are in terms of our funding, our response to the demands of the rule of law. The World Justice Project ranks Kenya as number 83 out of 142 countries on constraints on government power. It ranks Kenya as number 133 out of 142 globally regarding absence of corruption. I think we are doing well. We have defeated some 9. But I was wondering, many of you are here are parents, and if your son came home with a report card, and you are this parent who says, I don't care about performance, but your child says, I was number 133 out of 142. I don't know what it means to you. It ranks Kenya as number 126 out of 142 on order and security. Generally, Kenya's performance on the rule of law index by certain World Bank statistics now is at 41%. I have been looking at these statistics against the old adage that numbers don't lie. And therefore, we have every reason to put, I think, our hands on our faces in shame in terms of how we are performing among the community of nations. And I'm aware that many of us here, including myself, may find it easy to dismiss these statistics as they are from Western countries. They are from Western-leaning institutions. They have nothing positive to say about us as Africans. They don't truly represent our situation. But I pose as a question, which is the alternative index that we have developed that is homegrown, that is African, that is Kenyan, that will give us an alternative narrative to this narrative? In the absence of that, then we must leave this with these statistics as somewhat reflective of what our situation is in the scheme of things. I was taught in my legal theory classes that if we don't create our own knowledge, we must therefore be prepared to be dominated by others, those who create the knowledge. I seem to have had the same feedback from the AI session yesterday, when unless we create our own language, our own AI tools, AI has the biases of those who create it, and therefore we will be dominated along the lines of the biases of those who create it. I make it as an unequivocal challenge to the Law Society of Kenya, which means all of us sitting here, that we have an obligation to develop and administer a tool to assess our country's performance on the rule of law index. This tool, I suggest, can evaluate the various sectors or departments of government at both levels of government. The tool can therefore operate as a tool of accountability. One of the Kenyan ethnic communities are saying that a hyena does not hate the person who sees it. It hates one who calls others to see it. This tool can give us the basis of calling others to see those who violate expectations of the rule of law. And I believe if we don't find sufficient justification in our objectives as the LSK to create this tool, then I'll point out at one objective that you can say you are developing this tool in pursuit of. That is the objective to do all such other things as are incidental to the attainment of all or any of the foregoing objectives. It's imperative to note, to recognize that the rule of law has transformed from a mere aspect of legal or political rhetoric many years ago into a fundamental ideal that propels global economic development and sustainability in thinking. And when I talk about the rule of law in the Kenyan context, what is it that first comes into our minds? A number of things may come to our minds. Call out the police when they arbitrarily arrest our Gen Z protesters. Call out the head of the executive for referring to justices of the courts as wakora. Demand that all organs of government obey decisions of our courts, among other things. These are correct observations for those of us who are concerned by the state of the rule of law in our society. Save just to point out that these are anecdotal concerns. We need to grow to a stage where we are able to have what I regard as evidence-based decision-making, where we have an objective tool that tells the full picture. And from that picture, we are therefore able to fashion more sustainable interventions. I make out a case that if we play our role in securing the rule of law as a social value, as something that is not told to us from the outside, as something that we reflect on in all that we do, then whatever development initiatives we undertake are grounded initiatives that may fit the other principle of sustainable development. Sustainable development, as we speak today, plays a role across very many important aspects of our society: economic development, social development, environmental sustainability, and good governance. I wish to spend a few more minutes talking about the element that we were referred to earlier called artificial intelligence. It is one of the themes of this conference. I regard myself in that space as a digital immigrant. I trust that none in this room will begrudge me when I make the assertion, as I make, that most people in this room are in fact digital immigrants. And before I get attacks in response, I have two justifications for this assertion. Number one, the people who genuinely and truthfully call themselves digital natives, the generation Zoomers, are rather young, and they are yet to become lawyers in their numbers. Hence, they are not legitimate participants in this room. So they are out there. And the few of them who have become lawyers are yet to marshal the requisite economic muscle so that one requires to pay for travel to the South Coast and attend to this event. Permit me, therefore, for purposes of this presentation, to unequivocally declare that this is a conference of digital immigrants. Persons who are otherwise analog by nativity, but whom circumstances have migrated into the digital world. We are therefore a collection of people who are responding to culture shocks in this new world at different paces. Some of us are responding faster, others slower, others are opting out because they just can't bear. For the comfort of all of us, I don't intend this to be insults. I intend to be a sufficiently truthful remark and something that calls us to order and to action in terms of building our capacity. I'll make a very overall observation that artificial intelligence is now becoming a reality of our everyday lives. Our chief guest spoke about this today, and I will not want to repeat what he said earlier, but I may be saying that as a measure of comfort. It may that I have nothing to say about it, being an immigrant myself. I want to point out that AI is now being used as a search and discovery tool in research, as a document drafting and management tool, as a predictive analytical tool, as a reading and summarizing tool, as a scheduling and filing tool, as a client communication and support tool, and as a learning and marketing tool. I don't know about many of you. For those of us who are still suffering these shocks, every time I get an automated response to my email, I feel a bit disappointed because I wanted a human touch to my response. I am glad that the LSK Strategic Plan 2023 to 2027 recognizes AI and automation as opportunities for lawyers. I am glad because by looking at it as an opportunity for lawyers, we are going to have a positive approach towards it. We could have looked at it as a challenge for lawyers, in which case we are attuned to fight challenges. We are attuned to pursue opportunities. So that strategic approach by the LSK on this subject is something that I find significant. Amidst this surge of technology, I propose that we need to continue reflecting on the broad principle of the rule of law to realign it with the reality of a fast evolving technological world characterized currently by artificial intelligence. We need to be at the forefront in advocating for legal reforms. When I sat in the session yesterday, in the other room dealing with AI, there were significant questions about, do we have sufficient regulatory environment? And I think there was consensus that we don't have enough law on this subject. And I think there is no body of people best placed to push for an appropriate and adequate regulatory environment than we lawyers. And to satisfactorily push for a regulatory environment, we need to know something about it, because it is difficult to reform what you don't know. We need to emphasize ethical standards in the adoption and mainstreaming of AI. We need to play our role in promoting legal awareness and demanding accountability. And we need to see the role of AI in enhancing access to justice. I want to propose some things in conclusion of these remarks. And the conclusion is, how shall we, as advocates, succeed in recentering the rule of law to create a sustainable future and embrace AI in this fast-changing world? I propose two solutions in this presentation, namely a psychological, communal, as well as personal commitment to reform, and the broad concept of investment in legal excellence. On the question of commitment to reform, I want to share with you my learnings from the writings of Professor Yash Palgai, a person I regard myself as Kenya's greatest constitutional expert to the world. He wrote, and I quote, "Those familiar with Kenya's past regimes will immediately recognize how the Constitution seeks to revolutionize state and society. A major obstacle to its implementation is that the state is the primary source of power and wealth in society. Corruption is the principal vehicle of accumulation. Since a major preoccupation of the Constitution is safeguarding of public resources from plunder, the only way in which the ruling class could achieve its objectives is by systematic violation of the Constitution, benefiting from impunities that the political and legal systems have bestowed upon them. The question is whether those who are committed to reform of the state will be able to impose the discipline of the Constitution to the ruling class." And that's the question I pose to you. Are you, in the first instance, committed to reform? In the second instance, do you have the requisite physical and mental wherewithal to impose the discipline of the Constitution on the ruling class? I regard myself as least qualified to add any further explanations to the writings of Yash Palgai. The second theme that I wish to reflect on is the theme of investment in legal excellence. There are three cases that I have been reading and rereading from our superior courts. I'll not give you the names of the cases because that may reveal the identities of the personalities involved in them, either as parties or still as advocates. But in case number one, a judicial officer observes, and I quote, "Some pleadings and actions of some parties are so bad that it pains the court when going through them, and it wishes that they were never filed or done respectively. They depress the court, and that is not healthy at all. In my humble view, the pleadings in the form of the application before me, the supporting affidavit, and even the grounds of opposition," the judge is saying both parties involved, "thereto were so poorly drawn that they did not pass for those drawn by a qualified lawyer. In my humble view, if it were possible, all law schools in the country should take hold of and use them as teaching aids in civil procedure classes so as to remind students of what they should not do in drafting their pleadings." The second case, a judge is telling us, and I quote, "The application before me, dated 16th December 2020, I cited this date to show you recency of history, is yet another poignant and disturbing reminder that the craft of litigation in this country, and specifically appellate litigation, is fast sinking towards the nadir and calls for urgent and concerted efforts to arrest the slide towards a point of no return beyond retrieval. I can only hope that judges, law schools, and senior practitioners see the lapses such as revealed in the motion before me as symptomatic of the broken window that, unchecked, can only be a harbinger of worse to come. The third and final case is, the judge observes, and I quote, "While it is left of parties to decide how they move court, it is not open for a developing society to live on copying and pasting anything and everything. Law schools should remind their students that it behooves them to show that they read law. And that is why they are called learned friends. Friends of both each other and books." I don't know how many of us know that that's part of our friendships. This is one of those other decisions our law schools should always use in their civil procedure and legal drafting classes to guide students to be careful in how they apply their minds to drafting of documents. It is not all about copying and pastings. Colleagues, can we honestly, can we in good conscience, can we in good faith, these are non extras to our president, pride ourselves as champions of the greater ideals of the rule of law if these three observations by judges about us are true? I suggest that we can't. Number two, I am also cognizant of the fact that these three observations may not be fully representative of the dominant status of our profession and its professionals. Let's assume they are the minority. We will nevertheless have to hide our heads in shame in the knowledge that there are some among us that genuinely attract these observations. To remedy this trend, I suggest the need for inculcation of a culture of robust mentorship in this profession, not just by all members of this profession, but by worthy mentors from this profession. I say this advisedly because I've been in the academy long enough to know that there are people who carry themselves out as mentors, but when you observe them, you wish that your son or daughter should never move close to them as their mentors. I wish to also make out a case, and I'll take a bit of time on this, on the need to institutionalize publication of legal histories and biographies as a series covering excellent men and women across all cadres of our profession. There will be excellent men and women in all areas of the legal profession. Why do I say this? We saw Senior Counsel Pharaoh's Norov stand where I stand today and talk to us yesterday, and you can tell he has put in quite a bit of years. And the question is, how many of us know Pharaoh's Norov? I feel very depressed oftentimes as a practitioner when I ask my own students in school or my own pupils in chambers whether they know some of these legal personalities, and in extreme fear, not fear of lack of knowledge, fear of the person asking, they say they don't know them. And I make this knowing that a society that does not respect its history is a society that is incapable of sustainable development. Because that society will learn nothing from history, and therefore the positives of history will not inform what that society does, but worse still, that society will repeat all its historical mistakes. And that is sad. I trust that there are men and women in this room who aspire to run for political office in the LSK, I excluded. I want to give one more campaign agenda to those people to put on their colorful posters that, well, if elected, they will set up a directorate of the histories and biographies of this profession. I believe that immortalization of men and women who have made stellar contributions to the ideals of our profession may incentivize incoming members to invest in excellence. They will see the reason to invest in excellence. It will also discourage those who specialize in conduct that is inimical to excellence, and therefore we may end up realizing a profession that has significant rise in terms of its demonstration of excellence. I know that the chief guest poured significant praise to Kenyan lawyers for being outstanding lawyers in the region. And that's not something I doubt, as somebody who has done a bit of cross-border practice at our regional court. I know what Kenyan lawyers are capable of. But I also know that the remarks that I've observed above from 3 judges are being said of Kenyan lawyers. The question is, how do we extend our hands to hold those lawyers so that we bridge and, if possible, eliminate that gap? Welcome, Senior Counsel Feroz Norovji. Thank you so much for joining us. In this series, would also observe that we have men and women who did a significant role. When Feroz Norovji asked here who was the first black lawyer in this country, I thought I was sitting somewhere that was CMG Agwin Skortek. I was wrong. Why? It is because we don't have significant documentation of the men and women who have pushed this profession the far we have come. I was sharing thoughts with colleagues, Mr. Githeka and Mr. Ongicho out there. And by the way, for those of you who may not know, Mr. Ongicho has been consistently and without fail for any year involved in the organization of this conference for 18 consecutive years. 18 consecutive years. Mr. Githeka has consistently been involved in organizing this conference for 15 consecutive years. I hazard to add that they earn no allowance for that participation. That commitment must be documented somewhere. Senior Mercy, Dr. Mercy Mwara Deche, I remember reading on social media somewhere where I was among those who actively attended those wise spaces by Gen Zs. And they did a very good job. And we stand here and celebrate them, and we'll continue to stand and celebrate them and honor them because they have shown that it is possible to call a country to account. But in the course of that calling of the country to account, they would sometimes say, our foolish parents. And I kept saying, no. Those foolish parents of theirs also include Senior Feroz Norovji. Do they know that somebody is responsible by their blood, their breath, and their liberty for the existence of Article 37 in the Constitution that now gives us the basis of 25th of June, 2024? So it is in the absence of this historization and documentation of outstanding members in our societies that makes that consequence possible. I therefore pose it as a challenge to all of us who are here to see what you can do in our own small way. And by the way, for those of you who joined this profession and found research going on at kenyalaw.org, EKLR, you may not believe it, that all of us used to walk to Mr. Ongicho's chamber at A.H. Malik Advocates to pick decisions that he would have used his private time to do an analysis on before we go to court to argue cases. It only became worse when he was the advocate on the other side. You wondered how you'd go to ask for authorities from your adversary before you argue your case in court. I'm making out a case, good people, that these contributions are so significant when considered in their time and space that they should not go undocumented. And I trust that if we do this, we will have laid a solid foundation upon which we can then attempt to recenter the rule of law and lay a solid ground for sustainable development in a fast-changing world. And I thank you for that.